Hello, everyone. We're going to give it about 3 minutes for everybody's Zoom to kind of update if it's necessary or log in. So we should get started here at 11:33. So stay tuned for just a minute. Make sure.
Greg, how you doing today?
Good, Charlie. How are you?
It's another beautiful day.
Sure is. With a
If,
20-degree temperature swing.
right, I was going to say if the sun could come out a little bit, I mean, it'd make it a lot better, but here we are.
Agreed. I think we just need it. I want as much sun as possible in Michigan for as long as possible. No question.
Absolutely.
No question. Right on. Giving it another minute for some of the Zoom folks to hop in. I see a steady flow of people just coming in, so I'll give it a minute till about 11:33 and then give it a go. All right. Well, I want to thank everyone and welcome you to our Informing the Industry webinar, which I like Miller Johnson's title for the event better. What you need to know in 2025 related to MIOSHA. My name is Greg George. I'm the president of ABC Western Michigan. So thank you all for joining us for the last 30 minutes of the morning. And we have Marcus, Sandra, and Jacob here to present. For us, we were hearing from members in different peer groups and board meetings about kind of the increased number of inspections and citations and appeals, and just thought it would be a good time to end some turnover at MIOSHA specifically. So why not just bring in some experts who are great with legal and compliance related to this specific subject and kind of walk us through different topics. So I want to thank Miller Johnson for agreeing to support us in this event, and feel free to take it away.
Great, thank you. Thank you, Greg. I appreciate that. I'd like to say thank you to Greg and his staff at ABC West Michigan for setting this up. This is always a great opportunity to reach out and talk to so many people about such an important topic. And I'd like to thank everybody for attending. I know that you are all very busy, so I appreciate you taking some time out to attend this presentation today. My name is Marcus Campbell, and I'm here with Sandy Andre and Jacob Williams. We are part of Miller Johnson's Occupational Safety and Health Practice Group. One of our specialties is OSHA and MIOSHA related issues. And today we got to click that, Sandy. are going to talk about MIOSHA. We're going to talk a little bit about MIOSHA inspections, some things that trigger them. We're going to give some best practices on interacting with MIOSHA safety officers. As Greg had noted earlier, there's been some turnover, so we're seeing quite a few new safety officers out there. We're going to talk about some of the rights and obligations we have during inspections. We'll talk about common citations, and we'll get in a little bit on the appeals process so you can understand how that works. We'll give you some information about some best practices and some new legal updates we have on some new legal issues that are happening at MIOSHA. And without further ado, I will hand this off to Jacob to start us off.
All right, good morning, everyone. My name is Jacob Williams. I'm obviously here in our labor and employment group here at Miller Johnson. And, as we get started, I think one of the first things we wanted to go over is why do we have MIOSHA and not OSHA? So OSHA is the Occupational Safety and Health Act. It's a federal law that establishes workplace standards for health and safety. That's not going to be news to anyone here. And there's the agency itself, the Occupational Safety and Health Administration, that actually enforces those standards. Those are all federal standards, but the OSHA Act gives states the ability to implement their own plan, the state plan, recognizing that there are specific regional concerns, industry concerns, or what have you, that a state may want to take their own spearhead in enforcing. And Michigan is one of those states that has a state plan. There's about 20 or so that have one, and a small handful of states that have a state plan specifically for public sector employees. So MIOSHA can set a higher standard than what OSHA prescribes, not lower, but they can prescribe a higher standard. And the reason why we wanted to emphasize this point today, and it may be a point that many of you are already familiar with it, of this distinction between MIOSHA and OSHA, is that you're probably seeing a lot in the news, things like budget cuts or rolling back certain standards at the federal level, given new enforcement priorities of the current administration. To the extent that you're seeing those are only going to be at the federal level. And any of those changes are only going to affect Michigan to the extent that MIOSHA decides to follow those changes as well. So for the most part, if you're seeing those rollbacks, those budget cuts at the federal level for Michigan, it's pretty much just going to continue being business as usual. Let's talk about inspections and why they happen. One bucket of inspections that we see are programmed inspections. These are, thematically designed by MIOSHA to look at specific interests that they have. This could be things that are based on a particular industry, a particular region, a type of job site, any type of specific hazard that they're interested in. And these enforcement priorities are usually announced prior to, this campaign of looking for specific enforcement. Right now, a couple of the things that MIOSHA is interested in is heat illness and fall protection. We'll get into those a little bit more in the next slide and some of the other current emphasis programs. So, a focused inspection can be looking for those specific hazards when they come to your site, or they can be in a wall-to-wall inspection. And that's going to be when the inspector comes and wants to take a look at everything that you have going on at your site with those enhanced focused in mind. Of course, one of the focuses that MIOSHA and every other state is always going to have in mind are the fatal four: falls, getting struck by something, forklifts, getting backed over, hit by a car, caught in anything that spins, crushes, pinch points. Those are big issues. And electrocutions. These are the really serious things that cause workplace fatalities and injuries. So under the emphasis programs, like I mentioned, heat is one that MIOSHA is looking at quite a bit. There's going to be things involved in heat standards like monitoring the heat index, acclimatization for workers, ensuring that you have sufficient break time for them, hydration, training programs to help workers, spot either within themselves heat exhaustion or heat stroke, or be able to spot it within others. So there's some new standards coming out on heat. Silica, we've known for 100+ years, silica is really bad for human beings, but there's new research in the last 10 years that it might actually be quite a bit worse than previously understood. And Michigan, I didn't know this until yesterday, is one of the top states for silica induced illnesses. And so that's a really high emphasis for MIOSHA. For construction in particular, if you're working with products like concrete or other things that have a high silica content that you're cutting, grinding, or otherwise abrading, silica standards are going to play an important role in what MIOSHA is looking at on your work site. Excavating and trenching, this is always a big one. This is one of the more dangerous things that you can do at a job site. It's very high hazard. And, it's not just, at work. I mean, every 4th of July, there's a kid who digs a hole at a beach in Michigan somewhere who ends up either, hopefully not getting killed. Sometimes it happens, sometimes just hospitalization. I mean, excavating and trenching is really one of the more dangerous things that happens at a work site or, just out in the world. So those are some of the current emphasis programs that are some of the more focused ones. There's fall prevention, which of course, another very high source of employee injury. Safety and health programs, these are always important to have in place. I think Sandy may touch on this a little bit later, but having an accident prevention plan in place, not only has the actual effect of trying to mitigate some of these risks, but is also going to show a MIOSHA inspector that you're taking these standards seriously. And the lack of an accident prevention plan in place could result in a higher classification for another violation that you might otherwise experience. Mental health in the workplace is something that, that MIOSHA is interested in. There's no standards on this yet. Right now, they're just looking at the general duty clause, but it's something that MIOSHA wants employers to bear in mind. Another emphasis area are youth workers. Frankly, if you have youth at the construction site, there are other statutes that are going to be more onerous than MIOSHA. Youth employment laws are fairly restrictive about working with power tools, working at height, anything hazardous like chemicals, and those other statutes like the FLSA or Michigan's Youth in Employment Act are going to be a little bit more serious. And I think for many of our construction clients, minors at the work site are not a particularly common thing that we're seeing. So those are all the programmed inspections. Unprogrammed inspections are probably, what'd you say, Marcus, 70% of what?
I agree, definitely the most.
At the site. These are going to come from employee complaints. This is where the vast majority of inspections are going to come from. An employee has an issue with the work site and they have MIOSHA come out. Another one will be accident reports. If you report to your workers' compensation carrier that you had an injury, that carrier is going to let MIOSHA know that something happened on the work site. Fat cats are a big one. These are the more serious incidents like a fatality or a hospitalization, an inpatient hospitalization of 3 or more workers that have some pretty strict timeline reporting requirements. Dodge reports, some of you may be familiar with Dodge and subscribe to it for bidding and identifying job opportunities. MIOSHA looks at it to identify where current job sites may be so they can go out to an active site and actually get an inspection done. And then of course you have drive-bys. This is just an inspector happens to see a site and maybe they see something non-compliant just driving past it. And that's sort of an unplanned way to have OSHA show up. I think we're going to Marcus for phases of MIOSHA.
Great, thanks, Jacob. We're going to talk a little bit now about the phases of a MIOSHA inspection. There's 4 general phases. One is arrival and entry at the job site. After that occurs, there'll be an opening conference with the safety officer. Then we'll have a walk around inspection, and then there'll be a closing conference afterwards. So when it comes to the arrival and entry, so the safety officer is going to show up, present his or her credentials and a business card. Are you entitled to any advance notice? That's a question I get a lot from clients. I didn't know about this. They should have called me ahead of time. And unfortunately, the answer to that is no. And usually you do not receive advance notice. Some of the programmed inspections, they'll let you know in advance when they're coming out and make sure that you have your individuals on the job site that day. But if it's an unprogrammed inspection, you are very unlikely going to get notice. And MIOSHA does not legally have to give you. Sometimes if you have a safety officer that's coming from a long way away, they'll give you a call in advance because they want to make sure that there's somebody there. to handle it, but usually you are not going to get advance notice. So the next question I get is, well, can I refuse to allow the safety officer onto my job site? And the answer is yes. You are absolutely allowed to do that. But what the safety officer will do will return to MIOSHA, have the AG get involved, and then they will return with a warrant and a police officer at your job site. And that might buy you some time, but usually it is going to make things worse. So we always recommend that cooperate as much as you possibly can. Now, under the field operations manual, the safety officer is required to reach his or her inspection site within 60 minutes. So when the safety officer shows up, we do not have to immediately take them exactly where they want to go. We can make them wait a little bit. But we should be reasonable about it. We should not make them wait an unnecessary amount of time, but having them wait a little bit until we get everything together on our end is absolutely acceptable, and I recommend it most of the time. A best practice for when MIOSHA shows up is, one, this is probably the most important thing, designate a couple people at your job site as the designated go-to contacts for handling MIOSHA inspections. Chances are they will just simply show up, and the first person they talk to will have no idea what to do. And it's important that you educate everybody. These are the 2 or 3 individuals that you talk to. Maybe it's a foreman, maybe it's a site manager. So everybody on that job site knows, okay, MIOSHA shows up, we're going to refer them to one of these 2 individuals. And then they will take it from there, because we will train them and let them know how to handle these things. As soon as the safety officer shows up, I recommend that you have the safety officer just wait in a designated area, maybe even the job trailer if you have one, just away from the job site while we do what we need to do to prepare for that MIOSHA inspection. And the most important thing is be nice. That is, if you get nasty with the safety officers, the inspections are always worse. Your citations are worse. Your fines are worse. That's just a fact. So to the extent you can be nice, you absolutely should. Now, employers are entitled to an opening conference at the beginning of every inspection. And you should have one. A lot of times the safety officer asks you, do you want to have an opening conference? And our answer should be yes. Management representatives are entitled to be there. If you're unionized and there's a union there, then a union representative is entitled to be present. You should be given a copy of any written complaint that was filed. It will be redacted, but you should be given a written copy. And so the next question is, well, how do I interact with the safety officer during the opening conference? You should ask questions. Ask them, why are you here? What is this all about? And if there's issues, they say, there are particular things that we think you're doing wrong on this job site. Well, how do we fix it? Ask them for abatement advice. They will ask you if they can photograph and videotape your job site, which they are permitted to do. And we should have a representative of the company accompany the safety officer during every walk-around investigation. They should not be doing the walk-around on their own. So we should have somebody with them at all times. Documents to have ready at the opening conference, definitely a copy of your accident prevention program, which you should have on every job site. They will absolutely want to see that. If you don't have it, you will likely be cited. They may want to see additional documentation, which are things that we can provide from the home office later, like the 300 logs, 300As, 301 injury reports, any written safety programs that we have, safety policies. They may ask for equipment inspection records to make sure that we have those, and other documentation, but those are things that we can supply later from the home office. And eventually the safety officer is going to want to see your workplace, the workplace postings at that job site as well. Best practices for an opening conference. Number one, always have one. They are very, very important. It helps us, most important thing is it helps us determine exactly what the safety officer is looking for. If there's one particular part of the job site that they are there to see, then at the opening conference, we find them out. And then what do? We take them to that part of the job site only. We don't want to take them around and show them the entire job site. We take them right there. If they want to look at one particular thing, that's what we're going to show them. Because anything that they see that is a potential hazard and violation, they can cite you for it. So in that opening conference, we kind of focus things as to what are you looking for? And then we take them exactly to that and try to show him or her nothing more. So during the opening conference, one of the things that I usually recommend is, while you're having the safety officer perhaps wait while we get things together to prepare for the inspection and during the opening conference, if you can have somebody on the job site go around and do what I call last minute house cleaning, fix any obvious hazards that you see. If you see trip hazards out there, fix those. If you've got uncapped rebar, get out there and cap that as quickly as you possibly can. Do all those things before that opening conference is over and the inspection begins. And because if those things are fixed before the safety officer gets out there and does his or her inspection, then you're not going to get cited on those things. So I think doing a little bit of house cleaning and making the safety officer wait a few minutes before the inspection begins is a good idea. The employer has the right to accompany the safety officer on a walk-around inspection. I always recommend that. We should have someone accompanying them, preferably somebody who's been trained and knows how to handle MIOSHA investigations. Only show the safety officer what he or she wants to see. We don't want to take them around the entire job site and show them everything. Just if they want to see one particular area, there was a trench in the back of the job site, then you take them right there, look at that, and hopefully they decide to simply leave after that. But only show them what they want to see and plan your route to get there accordingly. The safety officer is going to take some photos and video. I recommend that you take those as well. If the safety officer snaps a picture of something, our representative should snap a picture of it as well, just in case we have to, contest these citations down the road. Eventually, the safety officer will want to see all your required postings, so make sure you have those as well. And they may wish to interview employees on the job site. Safety officers can also interview employees after hours. It's pretty rare, but it is possible. They could also, if they feel that employees aren't being cooperative, they can subpoena them and tell them they're going to have to come to Lansing to discuss this. Now, that's actually happening a little more frequently now. You used to never see that. With some of the newer safety officers, we're actually seeing that happen. So just be aware of that. It's unlikely that would actually happen, but those threats are happening right now. So let's talk about some right to employee interviews this week. So when the employees are interviewed during the health and safety inspections, one of the things that we need to know is the employer has no right to attend a private interview with a non-management employee. Interviewing employees privately, as opposed to letting a representative of the employer sit in on that, that is kind of a new enforcement priority for MIOSHA. Back in the day, they would pretty much let you sit in on interviews with any employee during a health and safety inspection. That doesn't happen anymore. And if it is a non-management employee, they will want to interview them privately. And what we're seeing now, even in health and safety inspections, is MIOSHA is wanting to interview everyone privately, including management employees. So this started back in late 2022, and it has become more and more of a priority for MIOSHA every single year since then, especially when we're talking about MIOSHA discrimination investigations. That is where it is a real hot button topic. But just be aware, in your general health and safety investigations, the inspector will want to interview your non-management employees privately, and they may let you sit in on with a management employee, but they may not as well. So that's something to be aware of. What I would always tell your employees is they can request to have somebody present. Like, I want a representative with me. I want somebody from the company with me during this meeting. And what the guidance, new guidance from MIOSHA says is that the safety officer has to make a reasonable effort to honor that request. They may or may not honor it, but there is nothing wrong with either the non-management or management employee requesting, say, I'd feel more comfortable if I have somebody here with me in this meeting with you. And the safety officer will take it from there. They may or may not allow it. Now, when we're talking about MIOSHA discrimination investigations, those MIOSHA discrimination charges are when usually it's an employee that gets let go and says, they fired me because I reported safety violations or I turned them into MIOSHA. And then what happens is that complaint goes to a separate branch of MIOSHA, the discrimination division, and they come in and do an investigation. And what we have seen recently with the discrimination division is that they want completely private interviews with everyone. Absolutely every single person that they interview, it has to be done in private, and they will not allow anyone to sit in, and there is really no exceptions. So we're talking management employees, we're talking owners of the business. No matter who you ask for, they are saying no. Even attorneys. If somebody who's being interviewed says, I want my attorney to be here, in the past, they'd always allow that. Now they're saying, no, we're not going to do that. I don't really know where this is headed. I think they're eventually going to get sued, and we'll figure out exactly how far they can take this. But when we're talking about a discrimination investigation, be prepared is that they're going to want everyone to be completely private and not have anyone in that room with them. So just be prepared with that. And again, just like in your health and safety investigations, you can let the employees know, if you want somebody in that room with you, ask them. Absolutely. I don't know what the investigator is going to do, but they are free to ask that. All right, so when a safety officer is doing his or her inspection, they don't have the right to see operations that are not being performed at the time. So if a safety officer were to say, well, show me how you do this, how do you run this piece of equipment? I would make sure that you advise employees not to do that, because there have been situations where that is done, and then if they believe it's in an unsafe manner, you will see a citation based on that. So if they see equipment being performed in an unsafe manner, they can cite you for it, but I would not volunteer that and show them how we're doing things. That does happen occasionally. The MIOSHA Act gives employee representatives the right to participate in an inspection. So if there's a union representative, they have a right to accompany the inspector during a walk-around investigation, just as a member of management has a right to accompany them, which we will talk about later. There's a new walk-around rule that might expand access for third-party non-employee representatives, people like union business agents, perhaps. But we'll talk about that a little bit later on. Let's talk about abatement. So one important thing to do during the walk-around inspection is listen if you can, especially when it comes to abatement. A lot of times the safety officer will provide very good information about how to quickly and easily abate certain hazards. Listen to that. And that will help you later on down the road when it comes to, all right, are we going to challenge this and we need to abate this hazard? If you can abate something immediately during the walk around, I absolutely recommend you do it. They say, look, you need to do this and this and this to make this more safe. If it's something that can be done immediately, I recommend that you do it, because you have about a 50-50 chance that you're not going to get cited at all if you do immediately fix these things during the inspection. Of course, they can still cite you for it, but a lot of times they won't. So anything that you can quickly fix as you're going around during the walk around, I recommend that you absolutely do it. So at the end of the inspection, you'll be entitled to have what's called a closing conference. Nowadays, it's usually not held on the day of inspection. There's a time delay. But within a week, they'll come back and they'll usually have it. If there's any type of air sampling or other testing, it can be 6 to 8 months later that you have the closing conference. But most of the time, it's within about a week of the actual investigation. And they can be done in telephone or in person. Sometimes they're in person, more and more they're in telephone. If we're waiting on air quality testing and other types of sampling, that's always going to be done via telephone. But they can be done in person. And if the employees are unionized and have a representative, they should be included at the closing conference. If you want to have separate closing conferences, you are entitled to that under the Act. One for the employer and one for the employee representatives. If that's the case, then the employee representative will have their closing conference first and the employers will be second. And in that closing conference, the safety officer is going to review the proposed violations and means of abatement. During the closing conference, this is another part to listen, because you will find out exactly what the safety officer says the alleged hazards are and how to potentially fix that. Ask questions during the closing conference. The more information that you can get during that closing conference, the better off you will be. One, it will help you abate the hazards. And two, it will help you protest this. If you're going to challenge these citations, you will have more information to do that. So definitely ask questions and get as much information as you can during the closing conference. Now we'll turn it over to Sandy for some MIOSHA inspection survival tips.
Okay, so you just heard about kind of the 4 stages of a health and safety inspection. So what do we recommend on best practices to how to get through that? You heard Mark talk about this first bullet point a lot. Even though this feels like an adversarial process, right? MIOSHA isn't showing up on a work site just to tell you they're having a great day and tell you that you're doing a great job, right? They're there to look for things that are not compliant. And so we often see, right, the initial reaction to that is wanting to butt heads. But we'll ask you to fight against all of those motivations, and think of this as a non-adversarial process, and think of this as an educational opportunity. Certainly, if a safety officer sees that that's the approach you're taking, as well, if you indicate a posture that is more of wanting to learn, wanting to listen, wanting to hear what they have to say, that will certainly make for a more efficient visit, but also can be more effective because you're going to learn more about what they're looking for, how they're interpreting a standard, what they think, so that you can apply what they're thinking to the work site you're currently at. But the other work sites that you're thinking, oh gosh, we've got something very similar happening at another work site, and if this is how MIOSHA, this is the approach they're going to take, we can immediately implement those things over there as well. So we do not encourage you to argue with the safety officer, but if they have something wrong, or have some assumption or recite a fact, right? If they're visiting there due to a workplace injury, and during the opening conference, they recite, a version of events that is not accurate, feel free to correct those things in a non-adversarial way. But again, remember, these inspections are conducted to issue citations. And so while we want you to think about this as an educational opportunity and listen and engage with the safety officer to understand what they are asking and what they are looking for, this is not an opportunity to offer more information than you should. We often hear from clients that when a safety officer is saying, asking the employer about safety history or their safety plan, right? A client representative might talk about, well, we recently had all these other safety issues and we're working on them, or we're aware of them, or something like that, right? Go back to what Mark said a couple of slides ago, right? Figure out why the inspector is there, try to keep them in that fence of what they're looking for, and not offer more information that you need, but feel free to engage. Second, ask questions and document. As Mark mentioned, we do not recommend that you should have a safety officer walking around a work site unaccompanied ever. There should always be a company representative with that person. Sometimes we also often recommend that there be 2 people, right? Maybe your head safety person that's assigned to the job site, but maybe also somebody who's there to kind of scribe and take notes, right? When the safety officer is asking a question, when they're taking a video, when they're taking a picture, right? You've got somebody who's doing all of those things yourself. Right. So you're doing that during the inspection. But as Marcus mentioned earlier too, the closing conference is an opportunity for you to understand their findings. We're not to the point yet to know if they're going to issue a citation, what might be in that citation. But generally speaking, they're giving you a good idea of what they've seen and if they're inclined to cite you on some things. So this is your opportunity to engage with them and ask them for more information, ask them about the basis of why they think you violated a standard, what exactly they're looking for, right? Ask about tips for abatement. All of those pieces, this is your opportunity to really understand how the safety officer is seeing it, and kind of your last opportunity before we get to an appeal stage to correct any unclear or mistaken information. That's really important. So once the safety officer leaves, we also recommend that you take your time to document the visit for yourself as soon as possible. If you haven't had somebody going around with the safety officer and being a scribe, whatever management or company representative did accompany the safety officer, have them sit down and document. Okay, what did the safety officer look at? Who did they talk to? What did they see? If you know what employees they spoke to, it's perfectly appropriate for you to conduct your own interviews with those individuals, not in a coercive or retaliatory or threatening manner, but so that you can figure out, okay, what might we be dealing with here, right before we even get to a closing conference, and certainly before we get to a citation. We also recommend that at some point in the process, whether you do that, the second somebody walks out, the safety officer walks out the door, or you do that further down the line. But at some point, it's important for you, for your own records, to obtain a copy of MIOSHA's own inspection file through the Freedom of Information process. That's really important. You will see exactly what the safety officer is relying on, certainly if they're issuing any citations. You'll also receive summaries of witness statements. They will be heavily redacted, but you will get a general flavor of what individuals were telling this safety officer, right? So of course they're going to interview a company representative, and the company representative, we hope, is going to say all of the right things, right? We always follow this policy. We always discipline employees when they don't follow this safety practice. But you'll also see, right, the employees that they interview, if every single one of those employees said, I've never heard of this safety practice and I've never heard of anybody getting disciplined, right? Even if you don't agree with those employees' statements, you can recognize pretty quickly that you've got a disconnect between what the company thinks the process and procedure is and how your employees are interpreting it. So those records can be really helpful. Even if a citation never comes, you can really use those to provide some insight into your own kind of employee relations and safety strategy. Okay, so the inspection, the walk-around inspection is over. The closing conference has happened. Probably during that closing conference, you get a pretty good flavor of citations are coming your way. And then you open your mail right within a few weeks after the end of that closing conference, and there's a citation waiting for you. So here are the different types, the classifications of citations that you might receive. So the classification of serious, other than serious, failure to abate, willful or repeat, or de minimis, or sometimes you see a regulatory infraction. That is kind of the classification. And as you might guess, the monetary penalty that MIOSHA has the ability to work within depends on the classification. And as you can see here on the screen, what should jump off the page at you pretty quickly is the monetary fine structure we have under MIOSHA is much less than under federal OSHA. For example, a serious violation here under MIOSHA is a $7,000 maximum fine, but at federal OSHA, that's $16,550 and goes up from there, as you can see. So it's really important, right? What we've traditionally seen, what the three of us have traditionally seen, is that MIOSHA hasn't necessarily used the citations as a money-making venture for themselves. We often see citations that a client will have something cited as a serious classification, more often an other than serious classification with no monetary penalty at all, right? And their focus is really on abating whatever that hazard is. But it's important for you to know what economics you're dealing with when you do get a citation. As we look at the construction industry nationwide, here are the top 10 federal OSHA citations we're seeing in the construction industry. And this is pretty consistent with our experience when we're counseling clients too. Fall protection, hazard communication, fall protection training, different PPE, right? Eye and face protection, ladders, health and safety. Several pieces that Jacob talked about related to emphasis programs, right? Excavation and trenching, those pieces as well. Speaking of PPE, the slide before you saw eye and head protection and things like that as being one of the most commonly cited areas. MIOSHA and OSHA instituted some new guidance, so not an official rule, but some guidance that became effective in January. This new guidance requires all employers engaged in construction work to provide employees with PPE that properly fits the employee's body shape and size. This proper fit idea has always been a requirement under the general industry standards, but now it's an official requirement for the construction industry standard as well. So you get through your inspection, you have your closing conference, you request your FOIA records so you understand what the safety inspector was getting, and you get a citation in the mail. The next question we get is, what do we do now? And the idea, the first thing you should know about MIOSHA, the three of us were kind of joking together yesterday. One thing MIOSHA does very well is count days that an employer must respond to them and hold employers accountable to those timeframes. So it's important for you to know when you get a citation, if you are going to appeal that citation, you have 15 and what MIOSHA calls working days from the date you receive it, not necessarily the date on the citation. You have 15 working days to begin the appeal process. And if you don't, that citation becomes a final order or starts down the process to become a final order. So whoever is in charge of getting the mail, make sure they understand it's important to elevate those things to whomever the decision makers in your organization are going to be to determine if this is something that the organization is going to appeal or not. So appeal or settle, that is the question. So when you receive a citation, there are a couple of things that on the face of the citation you should be thinking about, okay? So to prove a citation or to prove a violation, MIOSHA is required to prove 4 what we call elements. Right? They must be able to say, yep, there is an applicable standard, right? This is not based on informal guidance we have, but on a rule, right? The hazard actually existed in violation of the standard. It wasn't some theoretical hazard, right? We didn't see a piece of equipment sitting over there that nobody was operating and nobody was near or anything like that. And we just think that there could be a hazard, right? We've got employees who were exposed to that hazard and the employer knew or should have known about the hazard, right? So what is the employer doing on a regular basis to walk around and observe their job site to understand what daily hazards might exist? And if MIOSHA can prove all of those elements, right, they have a solid basis for the citation. Like, let's just start there. The next piece, right, if they've gotten something wrong here, that's certainly something you want to think about. But the next piece you should look at on the face of the citation are the monetary penalties, right? A couple slides ago, we showed you the structure, the monetary penalty structure, right? And so if you're being cited for something serious, is that something that's more than $7,000, for example? That one area, is that something more than $7,000? If so, that's outside of the structure for monetary penalties, and that's something that you can appeal. Is something classified correctly? right? From a serious or other than serious or failure to abate or repeat. For example, if you get a citation for a repeat violation, if that is the first time you believe that your organization, so not just one facility or one work site, but organization wide, you as an employer, that's the first time that you believe that you've been cited for that, that is something to flag. When we think about a time period, okay, if we were cited for something 25 years ago, Sandy, could we be subject to a repeat violation now? The answer is yes. There's nothing in the actual statute that limits the time, right? The field operations manual and our experience with MIOSHA and federal OSHA is they do look at timeframes. In the construction industry, excuse me, they look at a 5-year time frame. In general industry, they look at 3 years. So it's important to think about those things as well. As Marcus mentioned a little while ago, right? And you're going around and you're doing the inspection and the safety officer is talking about abatement and you're asking questions about what they're looking for. Sometimes, right, you agree as the employer, yes, right, whatever our condition is meets those elements to substantiate and support a citation. And yep, the monetary penalty is correct. But abating this will be $2.5 million. And so that's certainly not something we can do within the 30 days that is on the face of this citation, right? So whether we can abate it at all, or whether we don't have enough time, those might be reasons that you want to appeal or appeal a citation versus settle. And then of course, do you have any kind of affirmative offense, right? Think about timeliness. MIOSHA has 90 days after the completion of the closing conference to issue a citation. There have been very few instances that I'm aware of that I've dealt with clients that they have issued citations outside of that time period, but it does happen. And so that's an easy piece to check. Was there any reason for us to challenge that the inspection was improper? Is abatement of whatever they're asking us to do, is that practically, technically, actually impossible? Or is there some other appropriate measure we can take to minimize that hazard instead of what the safety officer said we must do to abate? Those are all pieces too. But beyond each of those, the question we get more often is, we have this rule, we enforce this rule, and this employee was just doing it wrong that day. They knew the rule, they've been trained on it, they just decided to do something different. And so we think we can appeal this citation on that footing. And if you and I were in the elevator or we were neighbors and having a chat over the fence, we would all, as reasonable people, go, yeah, that seems right. But the actual standard to get a citation thrown out to prove employee misconduct is higher than you would think, right? There are requirements, just we talked about elements to support a citation. There are elements that you must be able to demonstrate to be able to prove that defense. So you've got to have a clear work rule and if it has a clear work rule related to whatever the issue is. And you need to be able to show that if this employee had followed that work rule, this violation would not have happened, right? Whatever somebody, right, entered the pointer plane of operation, a body part, whatever the situation is. You've got to be able to demonstrate that you have an effective mechanism to communicate those work rules to your employees, and you've got documentation about that. So, right, if the employee was trained on this work rule during their onboarding 25 years ago, but you've never talked to them about it since, that's probably not going to hit that standard. You've got procedures in place to discover violations of this work rule. So you've got some representative of the company, some management official who is doing regular walkarounds of this particular work site. And right, that you as the employer are invested in keeping the workplace safe, and you're going to see and immediately address when you see employees not following those work rules. And you have a track record that if there's been an incident in the past where an employee who has violated that particular work rule, those employees are consistently disciplined. And so again, the employee misconduct offense, we're always going to make it on your behalf, of course, but it's important for you as the employer to recognize how high of a hurdle that is to really demonstrate to MIOSHA. So you've got options. When you get the citation in the mail, it's important for you to think about, weigh all your options, right? On the face of the citation, go through that analysis. Our experience generally is that when you get a citation, right, MIOSHA knows they need to prove those elements. And so MIOSHA is very confident that you've actually violated the standard, and they feel very confident that they can prove their case. So making sure that whatever your defense is, you also feel equally as confident. Okay. And if you're not interested in appealing, right, a part of accepting whatever the monetary penalty is or agreeing to have the classification of citations on your record, you also have abatement obligations too. And so it's really important that you can also abide by those abatement obligations, making sure the problem is fixed, periodically monitor that issue, because you don't want to back yourself into the opportunity for repeat violation either at that same work site or any other work site. The other recommendation that we make as you're thinking about appeal or settle is to, if you haven't already done a request, a Freedom of Information Act request for the inspection records, you should be doing that at this point. These timelines move pretty quickly. And if you think that you're going to go through the appeal process and eventually end up in a pre-hearing conference or in hearing in front of a administrative law judge, you need to start the FOIA request process pretty quickly if you want to be able to have that information before the appeal process is closed. The other advantage of acting pretty quickly when you get a citation is you have the opportunity to have available to you a penalty reduction agreement. So essentially this, in most cases, for most instances, not all employers are eligible for a penalty reduction agreement, but when you are, it's essentially saying, hey, employer, if you accept these citations exactly as written, and you accept the abatement obligations that are on the face of those citations, we will automatically reduce the monetary penalties on these citations by 15%. Right? So if your motivation, you don't care as much about the classification and you agree that the violation occurred and you're not really concerned about your ability to abate, but you're more focused on the economic impact of whatever those citations are, penalty reduction agreement probably makes a lot of sense to you. But again, you've got that 15 days, and it's really important that you decide to settle through a PRA if it's available to you, or begin the appeal process within that time period. And as I mentioned, not all employers or citations qualify for PRAs. Generally speaking, if you've received a citation related to a fatality, or if you as the employer in the severe violator enforcement program, a PRA is not going to be available to you. Okay, so that's a lot. I'm going to hand it over back to Mark to talk about the appeal process. I think so.
That was me, but
Jacob.
We can breeze through it. So we'll talk briefly about the appeals process. I'll try and keep it relatively narrow in the interest of time, because I know Marcus has some exciting best practices and updates for us to talk about. If you have any, Sandy mentioned it twice, and I'll, just to drive the point home, mention it again. If you have any inkling that you're going to be challenging a citation that you received, the first thing you want to do is get out that FOIA request. MIOSHA is going to take a long time to respond, and they're going to physically mail you a CD with all of their documents on it, and you want to get that process started as early as possible. If you wait until you have a hearing scheduled with an ALJ, it's too late, and you're not going to have that information available to you. And there may be some useful things in there for you to rely on. So the process is like any other ordinary agency appeal process. The first thing you're going to do is have an informal conference with MIOSHA. Probably not going to settle the citation here or come to an agreement. So you're going to submit your first appeal to MIOSHA. And most of the time that appeal is just probably going to get denied. But this is the place where you want to put in all of your arguments and all of your bases for challenging the citation that Sandy mentioned, are the defenses or challenges to the penalty. This is where you want to put all of that together, because if you fail to include it here, you may not be able to rely on it later on in the process. So the first level appeal, more likely than not, it's going to get denied. And the same thing is probably going to happen at the second level appeal. It's at the pre-hearing settlement conference where 99% of these are going to come to some form of agreement, whether it's reclassification or reduction in penalty. If it doesn't get resolved there, you're going to go to a hearing in front of an administrative law judge. And the reason, most of these MIOSHA citations don't go beyond that point is frankly because of what Sandy mentioned about Michigan's penalties being quite a bit lower than OSHA's. There just is not the same financial incentive to litigate these citations unless you have some of these collateral issues like an expensive abatement process or infeasibility of the time that you have available to you to implement abatement. So without those collateral issues, there often just is not the economic incentive to go through with the ALJ process. And then after that, you're looking at a trial level of court for an appeal in the Michigan Court of Appeals. And if you want, we will happily take you to the Michigan Supreme Court. But odds are it's not economically worth it and not a good incentive. So pass it to Marcus so we can talk about updates and best practices.
Right. Make this quick because we have some other information to get to, and I know we are almost done. One of the number one questions that I get from clients is, what's the best way to avoid having to deal with MIOSHA? I mean, how can I limit my liability and not get in trouble with MIOSHA? And my answer is, for the last 25 years, has always been the same. Have a good, effective safety program. That's it. If you have a good safety program, there are fewer injuries, fewer MIOSHA inspections, employees are more engaged, there's less downtime, even your workers' comp costs will decrease. It's ultimately going to even save you money. But having a good, effective safety program at your organization is the best way to limit your liability when it comes to occupational safety and health. And generally, there are 7 things that are required. The number one thing, I won't hit all these things, but if you're going to have a good, effective safety program at your organization, management has to buy into it. They have to make a commitment. Leadership does. The CEO, the owner of the company, has to let employees know that we're behind this. This is important. This is something that is a priority for the organization. If you can allocate resources towards this, budget for it, put this in your budget. This is how important safety is to us. We are allocating this amount of money towards our safety program every year. You should have employee involvement. An effective safety program, not just hovering around and finding employees that are potentially violating MIOSHA standards, but have them be part of it. Have safety committees, take information from safety committees and make changes based on that information. When the employees are actually actively involved in it, your safety program is better, your workplace is safer, you're going to see fewer investigations and fewer MIOSHA fines. All right, so let's go. Another thing I want to mention quickly is that if you have temporary workers, you have to make sure that they are somehow involved and know about this safety program too, because you have some potential liability with respect to the temps as well. A lot of clients that I talk to say, well, these are temps, these are not my responsibility. If they're on their work site, working for you as the host employer, you are equally responsible for them, and you can be cited if they get injured. So to the extent that you have a good, effective safety program, try to get your temporary employees involved in that as much as you possibly can as well. So another big question that I get is, all right, after all this is said and done, clients come to me and say, Marcus, what could I have done to avoid all this, to make sure that this never happened? And is there anything that I could have done to avoid all of this? And chances are it's probably not. There are thousands and thousands of MIOSHA standards out there. If I walk through Miller Johnson right now, I could find 15 violations. That's just simply how it is. Chances are at some point, even the safest employer is going to get hit with a MIOSHA fine. Take safety seriously, have a great safety plan, and devote resources to it. And that is the best you can do. But if you're disappointed because you got hit for, let's say, one MIOSHA violation in the last 2 or 3 years, that's probably not that bad. It really isn't. There are just so many standards out there that chances are everybody right now in the state of Michigan, every employer is violating at least one of them right now. All right, so now I'll turn it over to Sandy to talk about some new MIOSHA guidance on non-employee third-party representatives.
Yeah, so a little bit earlier, we were talking about, right, those walk around inspections and who has the ability to be there. Certainly, we always recommend an employer, an employer representative, but if you have employees who are represented by a union, their union representative also has the ability to be there. But starting in March, MIOSHA amended one of their rules to essentially adopt and align with the new federal standard, this worker walk around representative designation process rule, a whole mouthful, but essentially just means that a third party that's not necessarily affiliated with your company and isn't a union representative has the ability to be part of those walk around inspections. And so why is this a big deal, right? Particularly in the construction industry, particularly if you are a non-union organization, right? You might have a union who is looking to organize your workers. One of those representatives could be one of these third parties. Your union representatives from other organizations, particularly on multi-employer work sites, community organizers, attorneys, right? All of these third party all of these third parties have the ability to join that walk around inspection. Okay, so they can accompany the safety officer during the walk around portion and participate in the opening and closing conferences. These individuals, just like your management representatives, right? They can't interfere with the inspection. They can't be using that time to do other things like solicit your employees or engage in some other type of activity. If they're saying, hey, I have the right to be here under this new walk around rule, that's the lane that they should be staying in. But you as the employer, right, you still have the right and you should exercise the right to restrict access of these third parties to any areas that might be have trade secrets or proprietary information that you have some significant concerns about third parties having knowledge of. So, right, what are some practical risks here? One, right, the union could give non-union work sites, could give access to non-union work sites under this guise of, right, union employees have significant safety expertise because they're in this business and that's why they should, right? That's kind of some of the justification for this rule, right? But we know what that opportunity could be. It could be an opening for those organizers to start to make relationship with your non-union employees, and so you should take that seriously. Plaintiffs' attorneys or experts could use those inspections to collect information for future lawsuits. Remember at the very beginning of the presentation, we talked about why do these inspections generally happen? And most of the time, it's the result of an employee complaint or some kind of workplace injury or incident, right? And so if that individual, that employee is represented in some way, right? Their attorney could be walking right along with the safety officer and getting some insight about your organization that they may not have the ability to get knowledge of through any other process. So it's really important for you to understand some of the things that are really at risk here. So how should you adapt? Right? Just like we talked about, it's really important for you to train people at the work site to understand who the designated company representative is when a MIOSHA safety officer comes on site. You should broaden that idea and have a trained kind of inspection team, right? Your go-to team when a safety officer shows up, provide them specific training, especially on how to handle some of these walk-around requests you might get from third parties. It's really important that if you want to raise the flag to say, right, this third party can't go into this area because we have proprietary information there, that you do the legwork to take a look around your work site or your facility and say, here's where we have those things so that we know that we can raise that flag. It's perfectly appropriate for you when you have visitors come to your work site. If you've got general rules related to visitors about always being escorted or signing confidentiality agreements, do not feel restricted in your ability to do that for these third-party representatives as well. Okay. Another current legal issue, something that came through the Michigan Supreme Court just in the last year or so, under this case here, Stagel versus Resource Technology Corporation, essentially provides a new avenue for whistleblowers to sue your company for retaliation, which is not a good thing. Generally speaking, an individual cannot bring what's called a public policy complaint if there's some other kind of statute that has an exclusive remedy. And so we know here in Michigan, we have MIOSHA in the discrimination section, investigates and provides a remedy for any kind of retaliation claim. But in this case, the Michigan Supreme Court said that's not an effective remedy. That statutory structure isn't effective for an employee to really be made whole as a result of being retaliated against by their employer for raising a safety concern. So that was a new interpretation. And so I'm sure there's going to be, the floodgates are going to open on that. So that's something to watch for as well. Another trend, and we're telling you, I mean, you're probably laughing like you guys are telling us, right? But another trend, right, there are labor industry shortages. And so there's all sorts of reasons that you might see changes in your organization, right? That turnover and that shortage, it goes directly to employee education on your own safety practices, if nothing else. So a good opportunity for you to remember to make sure you've got good policies, procedures, training programs, and that you really do have a culture of workplace safety. And so that is the end of our formal presentation. We thank you so much for being with us. We'll hand it back over to you, Greg.
Thanks, Sandy and Marcus and Jacob. There's a few questions in the chat, and I'll just quickly grab and read them. One is the right for the 60-minute time slot to have a safety officer present for the walk applicable to just the GC, or does the trade contractor have the right as well for a safety representative?
I think everybody has the right. Anybody who is subject to that inspection has the right, but it's only going to be 60 minutes period that they wait, period. That is it. So it's not like they're going to wait for other individuals to show up. Anybody who is subject to that inspection, which means the general contractor, as well as anybody else that is on that job, any subs and other contractors, it applies to them as well. But the 60-minute time period applies to one inspection period. So that's it. So it's not like the one subcontractor gets 60 minutes, then another one gets 60 minutes. So no, it's but it does apply to everyone.
Perfect. And I think the second question was kind of disregarded. And then the final one that I have in the chat is Michigan raising the nominal fines for citations? They're recalling at an event earlier this year where that was coming.
I haven't seen it. They have a statutory structure to allow them to do that, but that has not been our practical experience or anything we've seen come through.
Yeah, I haven't seen it yet.
Cool. Oh, there you go. Any follow-up questions for anyone? Can feel free to unmute and ask it if it's faster than typing it up. Feel free to do that. I'll give it a few seconds.
Will this training deck be shared with the group?
Yes,
Okay, thank you.
you bet. All right. Well, if you do have any follow-ups, their contact information is there as well, but you can always reach out to us and we can connect you with them as well if you don't have a sec to write them down. But you will get a recording and a copy of the presentation as soon as it uploads to our YouTube channel. So again, thanks to Sandy, Marcus, and Jacob for presenting. Thanks to all of you for taking the time to join us for the Informing the Industry webinar today. I hope you have a great rest of your day. Thanks again.
Thank you.
Thank you.
Thank you.
Thank you.